Hello everyone, and welcome back to our channel. Today we're exploring a significant legal battle unfolding in Pretoria, a constitutional damages case rooted in the unresolved injustices of the apartheid era. 25 survivors and relatives of individuals who forcibly disappeared, tortured, or killed during apartheid have taken the South African government to the High Court in Pretoria. They are seeking around R167 million in constitutional damages. This amount is intended to fund further investigations, private prosecutions, memorialization efforts, and public education about these unresolved cases, many of which were referred by the Truth and Reconciliation Commission (TRC) to law enforcement but were never pursued. The claimants argue that successive governments, especially under former President Thabo Mbeki, neglected constitutional obligations by failing to prosecute apartheid-era human rights violations where perpetrators were denied amnesty or never applied. They insist this failure amounts to a gross violation of their rights to equality, dignity, and life. In response, former President Thabo Mbeki and former Justice Minister Brigitte Mabandla have filed an application to intervene in the case, arguing they have a direct and substantial interest, since the damages claim is based on allegations of unlawful interference by their administrations. They deny any wrongdoing and describe the claims as a highly defamatory. Mbeki stated, "Our character is beyond all price," and asserted that, without their involvement, the court may hear only one side of the story. The Foundation for Human Rights, which supports the survivors, opposes their intervention, calling it absurd and a move that could distract from establishing state accountability. They emphasize that the relief is sought against the state, not individuals, and say that if Mbeki and Mabandla feel defamed, proper legal avenues exist outside this case. Family members, including the son of Fort Calata, one of the Craddock Four, also oppose the intervention. He argues there is no substantive personal claim against Mbeki or Mabandla here, and that the correct venue to probe alleged interference is the newly established Commission of Inquiry announced by President Ramaphosa. That commission will examine allegations of unlawful influence and obstruction within the prosecuting authorities, as promised by the presidency on April 30, 2025. The commission, headed by retired Constitutional Court Justice C.C. Kampiep, is expected to have the mandate to investigate executive interference in TRC cases dating back to 2003. Critics of the commission warn it may lack the authority to address constitutional damages, arguing it is merely advisory and could delay justice further. The Pretoria High Court is scheduled to hear Mbeki and Mabandla's intervention application on July 28, 2025. This preliminary step could shape the outcome significantly. If they are allowed to join, they will be able to challenge allegations directly. If not, the case may proceed alone against the government, as the claimants intend. Why this matters: this case could set a judicial precedent on how executive decisions, particularly those aimed at national unity, are weighed against constitutional duties of accountability. It is not merely about reputations but about how a democracy handles unresolved historical wrongs. Human rights advocates say it represents a critical moment to challenge the persistence of impunity in the democratic era. Call to action: if you found this breakdown helpful, please like this video, subscribe for more legal and political analysis, and comment below with your thoughts. Do you think Mbeki and Mabandla should be allowed to intervene? Is the Commission of Inquiry sufficient, or do survivors deserve direct court action now? Let us know. See you next time.